Good morning, thank you for joining us this morning. My name is Hannah Booth and I'm the Communications Manager here at Morpay. It's my pleasure to introduce the topic to you for this session, which is how to conduct fair, thorough and legally compliant HR investigations. In case after case that ends up at an employment tribunal, we see employers caught out because they didn't follow the necessary steps during the investigation process. So in this webinar, our seasoned expert, Carl Hardcastle, will outline how to conduct fair, thorough and legally compliant investigations to ensure justice and protect your business. A few points to make before we do start. The agenda for this morning, Carl will start off by explaining when and where investigations are used in the workplace. He'll then discuss how you can ensure the investigation process is fair and unbiased. Carl will also talk you through essential investigation skills and how to navigate legal and compliance considerations. And finally, Carl will also take you through how this contributes to a positive workplace culture. In terms of asking questions, you'll notice that your microphone is on mute, but we do definitely want to hear from you, especially for the live Q&A session at the end of the main presentation. So you'll see that there's a drop-down panel where you can submit your questions for that section. We have had an incredible response to this webinar, so I imagine we will have a lot of questions, but Carl will do his best to get through as many as he can. Also, if you are facing any technical difficulties, don't worry too much because we will be sending you all a recording. However, if you are facing technical difficulties, please do flag them in the question panel, because if lots of them come flooding through, we'll know we've got an issue at our end and we can do our best to fix that for you. Before I hand over to Carl, I'm conscious that we will have some people on the webinar this morning that aren't familiar with Morpay, so I'll give a very brief introduction. We provide payroll and HR software, as well as outsourcing services to UK businesses. We've been around since 1966, have all the accreditations you'd expect, and we're rated excellent on Trustpilot. Our promise is to make payroll and HR easy, and here's how we do it. We've built payroll and HR software that's easy. We deliver quality outsourcing options, and all this means worry-free compliance for businesses. On the side, you can see some of the businesses who trust us to take care of their payroll and HR. So that's enough from us, and now let's move on to today's presenter. If you've attended some of our webinars in the past, you'll be familiar with Carl. Carl's an employment law consultant at Morpay, and he's worked here for over 12 years. I'll now hand over to Carl, who will take you through this morning's presentation.
Thank you, Hannah. First of all, a very good morning to you all in Morpay's July webinar. We're kind of slide heavy today, so what I'll try and do is keep the pace up. Two reasons is these slides are available, as Hannah says, so you can read them at will. And the second reason is Hannah will beat me up if I go over time. So we'll keep things kind of moving. But before we move from this slide, why are we doing investigations today? Well, if you look at BBC, ITV and NatWest, they're in a little bit of hot water at the moment. They will have gone through investigations internally. Hopefully they will have followed all the correct procedure. And the second reason we're doing this topic today is it's the most important part of a tribunal. Tribunals are won and lost on investigations, and there's no two ways about it. If you watch a lot of TV drama and court drama, you'll see that there's a very clever question under cross-examination that wins the case. There's a very last bit of evidence that wins the case. That is usually not the case. Investigations are at the point where tribunals are won and lost. Okay, if I could ask Hannah to move on to the next slide, please. Okay, investigations are used when you have a problem in the workplace. Okay, let me read that bottom section. When an alleged misconduct has been raised, i.e. you have a manager come into your desk as either business owner or HR manager saying Joe Bloggs, I think, has done X. Okay, investigations are also done by management. We all know one employee whose performance needs improving. Now, before we put them on a performance improvement plan, what we need to do is investigate, find out what's behind that poor performance. And also, thirdly, is when an employee raises a grievance. I'm not happy with my shifts, my manager, my working conditions. We need to investigate before we come to any conclusion. And I'll come on to the legalities of that a little bit later, but you have a legal obligation to have a fair investigation procedure. Okay, if we can move on to the next slide, which is the core principles. The main takeaway from this slide is possibly the top bullet point there. The person carrying out the investigation should not be involved in the issue. Okay? What you don't want is an investigation officer that's also a witness. All of a sudden you've got a conflict. Also, you need to let an employee know that there is an investigation taking place. Okay? But the final bullet point, in limited circumstances, it may be unwise to inform your employee of the investigation. Now that sounds counter to kind of a natural process, but we see a good example, abuse in care homes. An employee has slapped a resident. The police may have to get involved, and they come first because you don't want to prejudice a trial. So what you might want to do is have a general chat with 2 or 3 witnesses. At that point, it's a CQC, it's a safeguarding issue, and it's also a police issue. So in very limited circumstances, please investigate very lightly and back off. If you're unsure what to do and you are a client of ours, then please ring the advice line. We run 24/7/365, and the earlier we can get involved is the better outcome. If you're not a client of ours, I'd like you to be a client of ours, and I'm sure we can help with that. But if you're not a client and don't intend to be a client, please take professional advice early on. There's an old phrase, nip it in the bud, and it's there for a reason. Okay. Okay, if we can move the slide on. Sound like Chris Whitty, don't I? I apologise for that. I mentioned at the top of this presentation that there's a legal obligation. Now, there's an organisation called ACAS. You may have heard of it, you may have not heard of it, but they kind of set the rules about employment law and what you need to do in every single step. Now, I'm not going to take you through this slide, but what I do want to point out, all grievances and most disciplinaries must go through an investigation stage. I'll come on to a bit of case law later, and I'll skirt over that so nobody panic. I appreciate it's the most boring thing on the planet, but nerds like me enjoy it. But facts must be established fairly early on. Okay, let's look at clarifying and establishing facts. Again, not reading through that. What I do want to say is the person carrying out an investigation shouldn't be involved. I mentioned that twice, and I mentioned it twice deliberately because it's important. But you need to establish facts. I'll tell you about a case I had a little while ago. A manufacturing client called me and said I had a complaint that one of my employees has been punched by his supervisor. My advice, as you'd expect, would be to go away and investigate. I got an email with 5 witness statements, so I thought, well, you know, we're now motoring. This is looking good. I opened them and read them. There was one witness statement saying I have been punched, and there was 4 witness statements saying John had told me he'd been punched in the canteen 2 hours later. So all of a sudden, what you think is you've got the facts, you don't have the facts. What you've got is one person's word against another, and it was because we tried to get in some depth at the investigation stage. We didn't succeed, but we headed things off at the pass. Okay, the other takeaway from this slide is have sufficient time. It's the bottom bullet point. Have sufficient time to the investigation to ensure you establish facts. Facts, not opinions. And the takeaway from that bullet point is if you dedicate enough staff time to investigate, you may say, well, that's going to take a day, 2 days. And the answer is, well, that's better than a 14-day tribunal. If you can nip things in the bud, I've used that phrase again, you may have wasted, quote unquote, wasted a day investigating. but if things start to snowball, if things start to establish, the investigation should be thorough. Okay, I want to chat about the next slide, please. Bias. We all know Joe Bloggs is always late, and therefore I've got a report that he's been late again today, so he must be late. We all know Sally from accounts is grumpy with customers. Please avoid bias during an investigation. Make sure you remain neutral, stay focused on the evidence, do not make assumptions, do not ask leading questions. Joe Bloggs is always rude to the managing director. Do you agree that this is just normal behaviour for him? That's a leading question. Don't ask that. Work on facts. Make sure your questions start with a who, why, when, where, how, rather than any confirmation bias. Okay, we can quickly move on. I mentioned bias, and I'd just like to just evolve that point slightly. There's conscious bias, which I've mentioned previously, of Joe Bloggs is always late, but there's unconscious bias. That's what we see around us, what we see in the press, what we judge our historical current viewpoint on. And I want to talk about something else, about confirmation bias, that's not on this screen. Confirmation bias is, how can I liken it? When you buy a new car, you drive it around, and for the next week, every third car on the road is the same make and model as yours. They have not made any cars, extra cars. It's just that you are looking out for a pattern, and you've got to be just a little bit against that when it comes to confirmation bias. So there's three biases: conscious, fairly obvious; unconscious, where you pick things up in the outside world; and confirmation bias is where you're looking for patterns that fit your own viewpoint. Okay, if I can just move on. Okay, again, I'm not going to read through this because it will take me too long. But again, the notes are there for all time. A copy will be emailed to you. And if I can just reiterate Hannah's point again, any questions that come up, please put them in the question box, and I'll try and answer as many as I can at the end of this session. You'll see from there, the first box, what, why, where, when, how. Really important questions. I know it sounds like a little bit schoolboy or schoolgirl or school there in this day and age, but finding facts and not finding opinion are really, really, really important in tribunal. I've spent many hours in tribunal, always in a professional context, I hasten to add, and I've seen witnesses turn to dust when you get a very, very good barrister cross-examining. If you can get the basics right, it'll really build up your case. Okay, if we can just please move on. Witness statements. Now, this is the primary source of evidence. Yes, of course, you may have CCTV, clocking records, statements from other people that are not your employees. But it's important that these people will be cross-examined in tribunal. It's important that their witness statements hold up to that proof. So all witnesses are given a copy of the interview notes to check and sign. They've got to make sure those were their words. Prepare witness statements based on the information witnesses give. Statements should be in the witness's own words. So some of the best witness statements I ever see are really badly written, poor punctuation, and that actually is a bit of a reverse psychology. Because if all the witness statements are all typed up in the same font and all look pretty much identical, that smells something not right. So the witnesses give their own version of events in their own words. And then we send a copy of the witness statements to the witness so they approve, date and sign and return. Bearing in mind, tribunal maybe 9, 12, 18 months away. So the more facts you get down now, because the brain fades, in 18 months' time, you've got that black and white and you can pop it under the judge's nose, and that is vitally important. The second item on this slide is the confidentiality of witness statements. Now, there is no absolute guarantee that the employee or the employee's lawyer is going to get these. It's known as disclosure. We've got to give evidence. But in certain circumstances, such where there's a genuine threat of violence, then you can treat the statements anonymously. But if there's anything less than that, such as, well, I don't want to bump into them in the local supermarket because it'll be uncomfortable, then the answer is no. All statements should be clearly identified as to who's made them. Your employee will get them at some point, and I'm sure if you were accused of something and you said, well, who said what about me? And the answer is, we're not telling you. I'm not sure as business owners or HR managers, you'd be really comfortable with that. Okay, that's witness statements. Suspension is a big one. Again, I'm not going to read that out. But what I will say is that when the hairs at the back of your neck start standing up, when you're reading witness statements, it's at that point you should be suspended. You should always suspend with pay. And you may say, well, that's not fair. This guy's been violent. This guy's been homophobic. This guy's been racist, and we're paying him wages. You're perfectly correct. It seems counterintuitive, but the idea is if we suspend with pay, we've not punished them before fair process. So if you suspend them without pay, their lawyer's argument in tribunal, and they will pry at this, is you punish them before you establish facts and before you established any fair disciplinary process. So suspension with pay, and this will get pried at. Suspension should always be a little bit of a last resort. Suspension's meant to be neutral, but realistically, there's a bit of a stigma in the office if there's been a bit of trouble and various people have had the witness statements taken, and then all of a sudden an employee goes missing, then there's a lot of pointing at their empty chair and gossip going about. So suspension, last resort. We have a lot of care homes as clients, and that's great. Regretfully, and it's rare, but it happens, there's abuse. A worker will strike a resident. So we do a fair investigation, needless to say, but rather than suspend, can they work in a different department? Can they work in the laundry? Can they work in the kitchen with no contact with residents? So suspension is important, but it should be taken at the right point after you've discounted any other ways of not suspending. Okay. Okay. When you've done your investigation, and I know we've had a little whistle stop tour through the investigation, you will come to one of three conclusions. The first conclusion may be misconduct. There is a case to answer. That could be general misconduct or gross misconduct, and as you're probably aware, there's a huge difference. At that point, you'll be recommending to the disciplinary officer that further action needs to be taken. You will be making recommendations. You will not be making conclusions. That's for the disciplinary chairperson to do, but you'll be saying, I've investigated thoroughly, I've witnessed statements, I've CCTV, I've whatever you've got, spreadsheets or whatever, and you'll be handing it over to the disciplinary office, who must be separate and ideally senior to the investigation officer, and you'll be saying, I'm not happy, here's my investigation pack, over to you. So that's the misconduct section. Informal concern, you've had a chat with Joe Bloggs again. He seems very popular, Hannah, this morning, doesn't he, Joe Bloggs?
He does.
Yeah, he was late 3 times last week. You investigate with him, you find out that his mother's not very well and had to be taken to the hospital. So you'll just sit down and give an informal concern with him to say, look, we're not happy. You need to sort things out. I appreciate life's complicated, but it's an informal outcome. Okay, so we've got formal, informal. And the final one there is a formal grievance. The employment relationship works 2 ways. Yes, of course, the employer has control over the employee, but the draconian days of do as I say and shut up are long gone. The employment tribunal put that right. So if an employee has got a problem with an employer, there is a legal obligation for the employer to raise a grievance, or the employee to raise a grievance, and that is thoroughly concluded. So investigations, one of three: misconduct, informal concern, or it will generate a formal grievance. Okay, there's three words I want you to take out of this slide. The first two are in the second, right at the end of the second bullet point: legal action. Tribunals bite hard, and they can bite very hard, and it doesn't matter if you are a small charity with 3 employees or you are a huge multinational conglomerate. A judge will fine you the precise same. So don't avoid getting anywhere near legal action if you can avoid it. And if you do a thorough investigation, it should put things off. And the third word out of 3 is in the final paragraph: ACAS. ACAS are twofold. First of all, they're a bit of a talking shop. So they ring you up and say, Joe Bloggs is not happy. He's there again, he gets about. Alternatively, ACAS set the rules how disciplinaries, grievances are handled. It's not more pay being difficult when you phone us. It's not your HR manager being difficult when you see them. It's a basic legal obligation. And we'll come on to a little bit of a case law later on where it all fell down purely because they didn't follow the correct procedure. Okay, if we can move on. Now, it's not just legal obligations that you've got to take into account. Okay, you want staff that understand that complaints have been investigated fairly and fully. You want to create an environment where management take employees seriously. You know, shut up, get back to your desk. You wouldn't have done that. It's not the correct answer. But as we've seen on a national level, reputational damage is never great. What you don't want to be is on Facebook, Twitter, Instagram, saying that your company is, I won't use the word I want to use, but is not a great employer. You do have reputational damage. We live in a world now where people are very eager to go to tribunal. The reason behind that is it's now free. Back in the olden days, I'm showing my age now, you had to pay money. So if a claimant, an ex-employee or a current employee wanted to go to tribunal, they would have to shell out cash. Now they don't have to do that. They just open up the laptop free of charge and there's a case established against you. Reputational damage, even if it's a terrible case, there's no prospects of success, they'll go around and just say they're taking you to court. So take things seriously early on and hopefully you can avoid any legal damage and any reputational damage. Okay, let's just move on. I did promise you an example case and here it comes. Okay, again, there's a lot of words on that slide and I'm not going to take you through it, so let me give you the highlights. The claimant, Miss Roots, was a legal secretary. She was given a written warning for racism. I'm not quite sure it was a written warning, but there we are, all about context. Then Miss Roots made a homophobic comment and racist comments in the business. And it's never easy to say, but she said that she would never speak to a lesbian because it's a deadly sin. Now, what happened is, well, you'd expect what happened. She was dismissed for gross misconduct. Racist, homophobic, you'd expect that to be a fair outcome. She took it to appeal. The appeal failed, so she was very firmly dismissed for gross misconduct. And on the surface of it, that looks a really fair and straightforward gross misconduct dismissal. However, if we move on to the next slide, I'm going to read that judgment at the top. That's either Mr. or Mrs. Judge saying, I have considered the size of the respondent's undertaking, i.e. they're a small firm. This is a small employer, but it is the law. Okay, it's a law firm and it was a well-drafted written policies. They had an external HR consultant that was used for the appeal within the range of reasonable responses, and that's how a tribunal judge will look at that test. The respondent's size and resources does not excuse the substantive and procedural unfairness in this case. So basically, she probably was racist, she probably was homophobic, but because they didn't get the foundations in, the case collapsed. So this is not a rare case. This is not something that we've had to dig out from a dusty old file. We see these happening day in, day out. Again, the takeaway, investigation, the most important part of the process. Okay, if we can just click along with one eye on the clock. Okay, again, I'm not going to read through that, but some highlights. What you might want to do is, if you have a current investigation now or in the future, you may want to drag these slides out and use this slide as a basic tick box exercise. Has my investigation been this? Okay, is it fair? Is it rigorous? Is it transparent, structured, sensitive? Again, I'm not reading it all out, don't panic. But that is the key takeaways for an effective investigation. It's the foundations to the building blocks, to the dismissal that's the roof, or grievance outcome that's the roof. Okay, I think we're coming in on time, so that's good. So if I can bob you over to the Q&A.
Thank you, Carl. Please keep dropping your questions into the Q&A panel, and we will work through as many as we can this morning. So thanks to everyone that's already posted their questions. We will start to run through them. So the first question, is it a legal requirement to have the notes of meetings signed by the colleague?
It's not a legal requirement, but it's best practice. The danger is you're in tribunal, your colleague is being cross-examined and he says, I never said that. Your defence would be, well, you have a file note that you've reviewed them, you've signed them and you've dated them. So it's not a legal requirement. It will make your advocate in the tribunal a lot more, have a lot more of an easier time.
Brilliant, thanks, Carl. Now, another question that we've received is, can you use video evidence, or are there situations where you can use video evidence and other situations where you potentially can't?
First of all, if you suspect a crime is going on, yes, you certainly can use video evidence, CCTV. It's a popular myth that staff have to sign a form to say that the CCTV on site. They don't, they've got to be aware of it. But no, it's perfectly acceptable to use it. Clearly, there's circumstances where it's not acceptable, such as changing rooms and things like that. But yeah, if you've got CCTV, somebody stealing something, that somebody being racist, homophobic, whatever, you can certainly use it.
Great, thank you, Carl. The next question is, can I use a return to work interview as the basis of an investigation, for instance, in an AWOL?
Short answer is yes, but it's dependent on the quality of that return to work. If that is, oh, I see you back, what was up with you, and it's a one-word answer, then probably not. But if it's a detailed return to work, yeah, well done, you've completed the investigation stage.
Okay, so let's have a look. Thank you for posting the questions, everyone. We will ask a few more. We've also got a question, how far back can evidence be? If a case comes forward now, can evidence be used that's over a year old?
It depends on the relevancy. As employers, you can only act on something as soon as you know about it. So if somebody, it's got to be Joe Bloggs, hasn't it? It's been him all day so far. But if Joe Bloggs steals something or takes money out of your bank account or something, and you only find out about it a year later, yes, you can. So old evidence can be good evidence, but it all depends if you've acted on it in a timely manner.
Thank you. We've also had a few questions around the person under investigation. So someone has asked, does the investigation process always need to involve an interview with the person under investigation? And someone else had asked, should an employee be informed at an early stage that an investigation is taking place?
It depends on circumstances, but at the investigation stage, unless your handbook says otherwise, an employee has got very little rights. So there's no need for a formal invite. You can choose when to investigate your employee tactically. Do you want to get your ducks in a row before you speak to the employee directly? But yes, they should be involved. Doesn't need a formal investigation. You can literally tap them on the shoulder, say, grab a coffee and follow me, and investigate the issues.
A few more questions about the interview notes and having them signed and what have you. So where the person you are investigating refuses to sign the notes, but you have a company witness or note taker, then where would you stand?
That's always safer to have a note taker present, because all of a sudden it'll be them that's being in court under cross-examination and not maybe the employee. But a tribunal works to a level of reasonable belief. You'll be aware that in criminal proceedings, it's beyond all reasonable doubt. Now, clearly, as employers, you do not have forensics, you do not have the ability to kick doors down, etc. But they will expect you to come up to a test of reasonable belief. So is it reasonable that that statement, although not signed, is genuine? Or is it a case of that's a hostile witness that's written something that shouldn't have been written? And if they won't sign it, the next question is why?
Thanks, Carl, that's really useful. We've also had a question around what happens if someone records on a mobile. So I'm assuming they mean maybe if someone is being investigated and they've recorded that conversation on their mobile phone without the employer realising that they are.
Yeah, we see that a lot. We live in a world now where everybody's got a recording device in their pocket, effectively 24 hours, 7 days a week. You will be recorded against your knowledge at some point. It normally is admissible in tribunal, but my only words of advice was there's no such thing as off the record. So your meeting runs clean, your investigation runs clean. If you say the words like, come on, you've done it, why don't you resign? And that's been recorded, that will fail very badly in tribunal.
Next question is, if the case is clear, for example, someone has been caught stealing, do you still need to conduct an investigation?
Regretfully, yes. Let's pick an example. It's Joe Bloggs. You see Joe Bloggs in the MD's office, in the MD's wallet or purse, removing 20 quid. You don't bother investigating. You simply bounce them through a very short procedure and dismiss them for gross misconduct for theft. Turns out the MD's wife or husband has asked them to pay the window cleaner out the MD's wallet. Even in glaringly obvious gross misconduct situations, investigations can be brief. Have you stolen that money, and if so, why? You know, why did you put that £10 in your pocket from the till? It'll take you 30 seconds, but you'll still fall foul of ACAS code of conduct. So the bizarre thing, somebody takes £10 out the till, puts it in the pocket, you dismiss them, and they've got long service. Even though clearly they're the thief, you will go to tribunal, and regretfully you will lose because procedurally you've not followed the correct process. Admittedly, the judge may not give him any money for his actions because he's effectively dismissed himself, but on a technicality, he can tell all his friends he's taken you to tribunal and he's won.
Thanks, Carl. The next question is, what would we do when the only witness is refusing to go on record?
Again, it would depend on the reasons they're refusing. If they fear violence or fear some repercussions to themselves or their family, then that's absolutely fine. If they're saying, I don't want to be a snitch, then regretfully, there's very little we can do with that. We'll turn up with tribunal with no evidence.
Thanks, Carl. We've also got another question around individuals who are on their probation period. So do you need to perform an investigation for poor performance during the individual's probation period, or can we proceed directly to end their employment?
This is a very good question. There's a technicality that I'm sure a few of you know about, but you need 2 years service to go to tribunal for unfair dismissal. That's, you dismiss me because I failed my probation. So you can, in certain circumstances, get straight to dismissal. With the majority of the cases, please don't do that. But if you are a customer of ours, please give us a call and we'll give you some more detailed advice.
Thanks, Carl. Right, we've got time for just a few more questions. We'll ask 2 or 3 more questions and then we will have to close it off there. But thank you very much to everyone who has asked a question so far. The next question, what if someone doesn't give much detail during an investigation? Can we move to disciplinary on reasonable doubt?
I think what we do is if there's not enough detail, we can re-investigate with them. Say, can you please elaborate? You can investigate with staff as much as you want. It's not a case of you've got one shot at investigating. You've got as many as you want. So if you've got a poor witness statement, go back and say to them, can you please tell me more? Where were you? Where were you stood? What day was it? Who else was involved? And you can get into some detail like that. But reasonable doubt, tribunals work on kind of a balance of probabilities effectively. So a poor witness statement, a decent lawyer will go through that like a hot knife through butter. So reinvestigate. Please don't go forward with shaky evidence if you can't avoid it.
Thanks, Carl. Right, 2 more questions. Second to last one. The person being investigated may have family members that also work for our business and they want them to be a witness. Can they be?
There's a little bit of a conflict of interest. You don't need me to tell you that. Investigate with them, but you are allowed to come to your own conclusions. If every family member says they've done nothing wrong, and you've got other people that are not family members saying they've done something very wrong, you can highlight that to the disciplinary chairperson and say, look, you've got to make them aware that that's his mother, that's his brother, and these other witness statements are from quote unquote clean employees with no axe to grind. But yeah, it's an important point to make. Again, we're coming back to confirmation bias. I have 2 daughters, they can do no wrong. Now, I'm fully aware that they can do wrong and do wrong. Hopefully they'll never listen to this. But it's a confirmation bias. Family members will give a favourable account to other family members and you are allowed to take that into account.
That's great. Thank you, Carl. So we will go in with our last question and then, like I say, we will need to close it off there, but we've had some absolutely brilliant questions this morning. So one final question, what happens if the person under investigation refuses to attend formal meetings due to continuous sickness? So how could you deal with that?
Okay, first of all, sickness is often thrown in as a way to avoid an investigation. I'm sure we've all seen staff go off with work-related stress when they're under pressure. What you'll find is more times than not, a lot of emails coming from them saying you're picking on me, you're only doing this to me because of X, Y, and Z. That's great because they now can communicate with us and investigations can be over email or WhatsApp or whatever. But if an employee absolutely stonewalls you, and we see it quite a bit on the advice line, and it's from staff that have seen too much American television or too much police cop dramas, they'll give the no comment kind of answer. And it just makes my head shake. That's not in our world. That's not in HR and employment law. The idea of the investigation is the employee gets to put their side across. And you can actually say to them, if you say to me, no comment once more, I will take that as you agree with the allegations. That they should be coming forward with their side of the story. And if they refuse to get involved in the investigation, then we'll go straight to disciplinary. And in the event of a tribunal, we'll highlight that to the judge. We'll have loads of file notes saying we invited them on the 1st, the 3rd, the 5th, the 9th, and they refused to engage with us. So what more could we have done?
Thanks, Carl. I think that Q&A session has been really useful. I'm sure you'll all agree. So just a few slides to finish up before we do close the webinar off for today. So to begin with, and we have got some of our Trustpilot reviews coming up on the screen now. This is for our HR services offering. Carl has mentioned our HR services offering briefly already this morning. Our advice line runs 24/7, 365 days a year. So no matter when an HR issue crops up, best practice employment law advice is always available over the phone, anytime, and delivered by our highly experienced team of qualified experts. Like I say, you can see some of our Trustpilot reviews here. We're rated excellent on Trustpilot, so you can trust the expert advice that you'll receive. If you would like to find out more, drop me a message in the question panel and I can arrange for one of my colleagues to contact you. And I will also mention at this stage, you may or may not be aware that Morpay recently acquired Natural HR, who specialise in best-in-class HR software. This means our HR software now contains more features, including workflows, employee engagement, recruitment, and also performance management functionality. Lots of you are probably aware of our Knowledge Centre. This is an area on our website that's packed full of helpful resources. You can find out about upcoming webinars there. There's also topical guides that you can download. There's lots of blogs on there. So please do go and have a look on there if you haven't already. There is loads of useful information within that section of our website, the Knowledge Centre. So that's everything from us for this morning. Thank you very much for attending the webinar. Like I say, we will send you a recording of the webinar and a copy of the slides. And thank you to Carl for hosting today. You've been absolutely fantastic. I hope you found it useful and we will hopefully see you on a future webinar soon. Thanks everyone.